Well, I went like last May. It's like, yeah, it was just a random.
Last one we had was pretty good.
Remember law school with law semester?
Oh wow.
She asked questions. And you will see us all that. Remember, and you got a picture of us. And you told us
Yeah, you laughed.
did we get a picture?
We got a picture. We should find that picture.
Where
That
did
is
it go?
awesome. So cute.
Remember taking your hair?
Is he okay with the family? Yeah, he's totally fine. Jack was too. My parents' dog was freaking out. He barked a little bit.
I love Lloyd. Lloyd is right. Lloyd, yeah. Oh, Wilson.
I was in some strength training ground in a sense. We only got him. Yeah.
Well behaved.
Yeah, he's pretty good. He's a little independent.
He has his own research, right?
Yeah.
Testing. Testing.
Well, ladies and gentlemen, good morning and welcome. My name is Daniel Sir, and it's my privilege on behalf of the Madison chapter of the Federalist Society to welcome you to this afternoon's program. For those of you who are joining us for the first time, the Federalist Society is a nationwide network of over 45,000 lawyers, law students, judges, and citizens who care about the Constitution. And we come together in particular around three principles: that the state exists to preserve freedom, that the separation of powers is fundamental to our constitutional order, and that the duty and role of the judiciary is to say what the law is, not what the law should be. And the program we've put together for you this morning, or this afternoon, I think will embrace all three of those principles and show in different aspects in both law and policy how they work out. And to lead that discussion, we have a great panel assembled for you. Our moderator will be Andrew Hitt. Andrew was the Assistant Secretary at the Department of Administration, and before that, the Department of Health Services for Governor Scott Walker. He serves on the board of UW Hospitals and is a former member of the Group Insurance Board for the state of Wisconsin, so he knows the healthcare space well. Next, we'll have Professor Howard Terber from the UW-Madison Department of Political Science and the law school as well. He received his PhD from Cornell in 1999 and also has a JD from the University of Washington. And he actually practiced law before going into academia, which is something we always appreciate about law professors. Tom Miller is a resident scholar at the American Enterprise Institute, which I would say is probably the most exciting place for policy ideas in Washington, D.C. today. He is a former senior health economist for the Joint Economic Committee in the United States Congress. And before all of that, he was a trial attorney, a journalist, and a sports broadcaster. So perhaps we'll see some of that at work today. And then after their conversation, we'll have an address from the senior United States Senator from the state of Wisconsin, the Honorable Ron Johnson. He is one of two accountants in Congress, and he also is the author of some legislation that he'll discuss in particular. And as the Federal Society, I want to show a special note of appreciation for his leadership on Wisconsin's judicial appointments. The state's two U.S. senators exercise a significant degree of influence on our federal judiciary, and Senator Johnson really took the lead in reforming Wisconsin's nominating commission process to make sure that we had full representation and a friend of many of us in the room, Rick Essenberg, is one of his appointees to that commission, and we've seen the results of his leadership. So we want to show our special appreciation for your leadership on judicial issues. With that, I will turn the program over to Andrew.
Great, thank you, Daniel. Well, I have two goals today. One, moderate a very interesting panel, and the second is not to fall off of this stage, because I got about an inch leeway here. So, introducing this topic is a little bit like going to... Okay. Thank you. Introducing this topic is a little like going to Green Bay to introduce the Packers to the people of Green Bay. You all know this topic. We've all read about the Obamacare or the Affordable Care Act, and we all know a great deal and have a great many feelings about the topic. So for an introduction, rather than repeat what we all know, I want to try to put it in perspective with a few facts and figures that have been released over the last couple of years. From Kaiser, the Washington Post, and the Wonk blog, there's reports of the uninsured rate dropping between 2.8% and 4.8% across the respective states. And for some demographic groups, those drops have been even more significant. Also from Kaiser and from Politico, 2016 premium increases for the Marketplace Silver plans are expected to be about 4.4%. For 2015, the Marketplace increase premiums was about 5.4%. Also from Kaiser, hospitals such as the Cleveland Clinic and hospitals across the country are seeing drastic reductions in their charity care. Charity care is what they write off for caring for people for the uninsured and are unable to collect from. They're seeing tens of millions of dollars drop in their charity care. From the Wall Street Journal, non-group policies are seeing proposed rate increases as high as 30%. And of course, there's much anecdotal evidence and discussion about group rates and the increases that employers and employees in group plans across the country are facing. There are enough numbers to go around to support everyone's argument in this case. Translation, a piece of national legislation, a piece of national policy has produced winners and losers. Go figure. The question remains, do we want a national health care policy that produces so many winners and losers? And even if we don't, is there something better out there? The lineup today, first we'll hear from Mr. Miller. He will provide a 10-minute analysis and reaction to the decision. Then Professor Schwaber will do the same with 5 minutes of rebuttal and back and forth. Then we'll hear from Senator Johnson for 15 minutes on congressional reaction, and we'll follow up with a Q&A. I'll try to keep time, and as time goes up, I'll try to motion you and eventually stand, I guess. So with that, I turn it over to Mr. Miller. Thank you.
Thank you very much, Andrew. Appreciate the opportunity to be here. Thanks also to Heather Belinsky and the chapter of the Federalist Society for hosting this event. I always believe in full disclosure when I make these talks. I was involved in the litigation, including the King case in the very beginning, going back to a forum we held at AEI in December of 2010, which actually found the problem in the law because someone eventually had to read what was in it. I was involved in launching the early wave of litigation right after the last Supreme Court case in June of 2012. We got into Oklahoma in federal court in September 2012. Subsequent cases after that. Now, I also give full disclosure, I always have a choice of neckwear. I was thinking about going with my usual one, which is my Duke Law basketball tie. I decided that wounds were still a little raw here in Wisconsin. I don't want to take my life in my own hands. I had a pretty good year back in Indy at the championship in April. We were fortunate to win. Also had another good year. My daughter's a rising senior at Ohio State, which is the reason for the Buckeye tie. I figure you're used to being beaten in the family, so that's okay. We'll see what happens in the next Big Ten championship. But we're going 2 for 2, and then we go into the third one, and it turns out it's a 2 for 3 year. And I might have been willing to swap one of those championships, probably the national title for OSU, for a different result in King. I'll talk about this in a little bit of a broad brush. You're knowledgeable folks who know the law, particularly Supreme Court litigation, and have less time than the standard oral argument, although without the interruptions. This is a basic case of statutory construction, they say, and a major case of political reconstruction. The essence is there were two types of exchanges set up under the Affordable Care Act, or Obamacare. Exchanges established by the state, which seemed to mean something under one section, and exchanges established by the federal government. The more important thing was there was another provision which defined what type of tax credits there would be and what the amounts would be. And in that provision, it tied them to exchanges established by the state. You'd think that would mean something. This is a law with a lot of unusual history. It was passed by many contortions, by any means possible, and literally the last way it could be passed was the way it was passed, and a few things weren't connected and left behind when it was done in March of 2010. Well, a couple of years later, eventually the Internal Revenue Service got around to enacting a regulation which defined what they thought this meant, despite what the law said. And so there were, over time, 4 different cases challenging that IRS rule in the federal courts, different types of plaintiffs, different jurisdictions. King was the one that got to the Supreme Court first, and a little bit of a surprise that the Supreme Court took cert on that last fall. The consequences, everybody made a big deal about the challenge of the subsidies and what that would mean. There were some other important policy consequences here, though. Because of the way everything was interconnected, what it meant was if the subsidies went down in the federal exchanges, it also meant that the employer mandate was not enforceable in those states, and most of the individual mandate was also negated. So that was a big opportunity to renegotiate and reconsider a lot of bad provisions in the law with the opportunity of a Supreme Court decision, which would open that up again. There were hits and misses in the lower courts, won some and lost some, different decisions. Essentially, most of the arguments were about the plain words of the statutory text, spell out what needed to be done, or could you manufacture ambiguity in the rest of this rather confusing law to say, well, we don't know really what it means, so let's go ahead and have the IRS make the decision under what's usually the Chevron-type approach. There are also ways to try to say within the larger texture and structure of the law what was essentially what Congress seemed to be doing. And you could argue both sides of that, and we got different results in different courts on that. We went to the Supreme Court in a 6-3 majority decision with Chief Justice Roberts writing the opinion, found out that what was clear was ambiguous, and what was ambiguous became very clear. It all depends how you want to look at the end of the telescope or kaleidoscope, as the case may be. Now, there are ways to rebut all of these complicating secondary provisions. It's a tedious exercise. It was done in the briefs, but that's a lot of work, and there are other ways in which courts sometimes decide these issues. Essentially, this was a consequentialist decision, at least if you take it from what it took to get Justice Kennedy and Chief Justice Roberts on board with him writing it. I think the other 4 votes are pretty much in the bank for anything that upheld the law. It was a results-driven decision to carry out the unfulfilled execution of some academic and abstract theories as to how health insurance should work. Great fears of a tremendous disaster, death spirals, the usual litany of type of things that are said in this regard. But in essence, we'll get a decision that's necessary to carry out whatever we think the statutory scheme is, and the particular words don't really matter. We'll work backwards from there. Some surprises were using the major questions doctrine, reviving that to bypass Chevron and administrative law. That's a muddled area to begin with. This was a little muddier afterwards. In essence, the court was saying, well, in this case, these decisions were not delegated to an agency like the IRS. Just about everything else was. The Secretary shall and a lot of other obscure provisions. This magnifies the role of the court, at least in this case selectively, to be able to fix, rewrite, and save statutes. Whose job is that really? Is it the court's job or the Congress? Well, we found out in this case the court would take it over. Justice Scalia in the dissent had a lot of great language. Nevertheless, there are only 3 votes. We're moving on with the law on that front. He, as usual, said, look to the language. It's clear in this case it's the job of Congress or the states, not the court, to fix any problems in the legislation. And sometimes you get the court to say this, that we're not going to fix laws. In this case, though, it was a little different because this was the ACA and Obamacare, and in cases like that, special rules seem to apply. It was a major question because it was Obamacare. What was the statutory purpose? To pass a law by any means necessary, and the rest of the details were somewhat beside the point because we rewrite it later through administrative rules. Why did the plaintiffs, petitioners who I was working with lose? One way to think of this is, aside from the fixation on the Great Meltdown, the idea that this was basically a law to set up a nationwide approach to health insurance and health care reform, rather than state-by-state choices, options, and vetoes, despite some language in the law, and that this was supposed to improve health insurance markets, despite the evidence we may be seeing to the contrary. Some have called this a pretextualism type of a statutory construction analysis. I would just call it a pretext instead. We have what is almost like Chevron step 0 has been speculated by some in this case, which is even if normally you'd say that the law is clear enough, you can stop at that stage. But here they're going even before that by saying this is even a matter committed to the agencies. It's all a blurry continuum now as to whether or not the courts want to uphold something or take it down. Kennedy and Roberts were able to trim Chevron marginally, but there are larger issues of political accountability at stake here. We've got administrative law more and more muddier, substituting the court in the place of Congress and the states and giving freer rein, as if they didn't already have it, to administrative reinterpreters, which will only get worse in the future. There's a long track record of this going on with the law in this administration. They made mistaken assumptions about how the states would react to this law and how the law would work and be received. This was not, though, what we would call a scrivener's error, which could be corrected. When you have these problems, you take them back to Congress and you vote on it again and you fix stuff up, or you find out you have to do something else. What did we achieve in this litigation? We gave states a voice where they didn't have one, a chance to express their strong feelings on this issue, as well as the Medicaid issue. Teed up the issue hypothetically for Congress if the court had go ahead and said, we can't fix this, it's up to you. And a lot of folks did some work in that regard to get ready for it. And frankly, we slowed down and annoyed a lot of folks who wanted to go even faster to other destinations along the way. And if you got the shot in front of you, you need to take it as opposed to bypassing it. That's basically the litigation in the court case. I mean, there's layers and layers of briefs, and digital trees have been killed over this and chewing it over. But that's what's been decided. It's not going to come back again. What's the real legacy of this? A lot of bitterness and resistance, somewhat emblematic of the law overall, because it's essentially continued to bypass politics. The country's moved in a different direction, but we have this stuck in place, and it's very hard to overturn the law, and certainly when courts are willing to prop it up. We were deprived of finding a route to a political compromise once again, where each side had to find out what they could live with, what they could do a little bit differently by voting on some key provisions again. It really wasn't a dispute about the subsidies. It was about everything else that goes around it and how you go about doing it. So we're going to need much more work on actually coming up with a tangible, credible, serious replace provision. Congress wasn't fully ready to go with that if the whistle blew the next day. They're going to have to do very soon. They're going to have to do the same thing in a presidential race. There are other cases going on that are nibbling at parts of the law. The origination clause case, I had a big argument made to me, hypothetically, we're still alive, we can go. It's not going to happen, although it is still alive in the courts, the House lawsuit challenging the appropriate, but they're not kind of, this was the last chance for a major blow that would redirect things and reopen the discussion over this law. So we're back to politics. Rhetoric and symbolism has not been enough thus far, despite some folks thinking it is. Why have a majority in Congress if you're not willing to vote on things and take the risk of losing on something and trying something else? Presidential campaign might be different in 2016 than 2012, but I wouldn't bet too heavily on it, given other things going on. What we do know is we've got a lot more administrative discretion to rewrite laws regardless of how they were passed. That's a bad thing for the country. That's bad for political accountability. It opens up more of the unchecked administrative state, and only once in a while a court will dive in, but it seems they only dive in to save things if it's politically necessary. So there's more to come in either direction, including what might change in a new administration using this type of administrative discretion to go in some other directions, and we'll see where we go from there. Thank you very much.
So, hello, my name is Howard Terber. I teach at UW Madison. Thank you all very, very much for having me here and for hosting this event. I think it's terrific, and I hope it will be interesting. We just heard a presentation that I think can be described as a mixture of politics and law, maybe about half and half. Or I'm going to take a different perspective. I'm going to sort of, in a way, tell the same story, but from the perspective of someone who watches courts and constitutional doctrine. And interestingly, when you tell the story that way, in some ways, what you arrive at are opposite conclusions, which is kind of interesting. So the basic argument, not to contradict anything, just to retell the story, was between one side that says, look, we have 100 years of principles of statutory construction, and the principles of statutory construction, the canons, tell us you must always read a statute in a way that will save it if possible, in a way that will effectuate its purpose, and a way that will not treat one clause as being inconsistent with the others. If you find a clause that's inconsistent with the others, you should indeed rewrite it. And the reason is, if you've ever tried to write something by committee, you know. It's impossible to write a 5-page essay by committee and have it be perfectly consistent. Try writing a 500-page bill or a 700-page bill through multiple committees, reconciliation, and 2 houses of Congress. And over a period of more than a century, our courts have established these very traditional, very well-established canons of construction, because otherwise the system would be literally unworkable. There are literally thousands of federal laws that would fail if we tried to test them by a strict direct reading of the language and consistency standard without these canons of construction. That's the argument on the one side. The argument on the other side was precisely this, which the three dissenters articulated very well in their opinions, is this is a special case. Those canons are fine for ordinary statutes, but this is a highly political case, a highly complex piece of legislation, a highly contentious piece of legislation, and one that's highly consequential. And therefore, without rejecting these canons of construction as they apply in cases of ordinary legislation, in a case like this one, we should hold Congress to its words. So from a purely legal perspective, the side arguing for special treatment were the dissenters, who argued that we should not apply the ordinary judicial canons of construction and deference to the legislative intent that we do. Now, this is not a new issue. Justice Scalia, in particular, was a long-time opponent of the idea of legislative intent in legislative interpretation. But these are a very well-established, very well-laid-out debate, and that became the question. In terms of how it was answered, I do think that the most interesting person to watch is Roberts. And I think, though, that to understand or to have a good theory about what was going on here, you have to read King versus Burwell along with other cases from the same term. So, for example, in the same term, in Bond versus the United States involving chemical weapons, sorry, that was the year before, in Yates, the fishing case, in the fair housing case, in all of those cases, Justice Scalia, for example, agreed that the plain language of the statute went one way, but voted a different way. He was perfectly happy to avoid the plain language in a different situation. I don't think it's because he's simply a policy-driven consequentialist hypocrite. I think it was because he was making an argument that this was a special case, that Obamacare and the ACA is a really consequential and important case. And we saw an argument just like that in Michigan versus EPA. And in that case, Justice Roberts did not show this tremendous deference to executive agencies. On the contrary, he did not apply Chevron deference at all. He said, because this is an important and consequential law, we will not apply Chevron deference. The court will do a, essentially, de novo review of the meaning of the statute and test the agency's actions directly against our understanding of that statute. That's quite radical, and it's the opposite. I mean, this is a bit of, you can think of the old days of delegation doctrine. This is a revival of strong judicial review of administrative action of a kind we have not seen in years, certainly since Chevron. So far from a reduction of that scrutiny, if you look at the EPA case, we see a remarkable spike in that activism, which raises the interesting question, why not the ACA case, right? Isn't that also an important law? Isn't that also consequential? In EPA, in Michigan versus EPA, Roberts said that the reason for not applying Chevron deference had to do with the importance of the law. Why not apply the same thing to the ACA? It's an interesting question, but let's take as a first observation that one way to read Roberts' actions is a shot across the bow in the separation of powers. A warning to the executive branch that agencies cannot count on Chevron deference. They might get it sometimes, they might not. It's not a given. And even so, for example, if you didn't follow the EPA case, the question was at what stage of the preceding cost-benefit analysis should be performed? Should a cost-benefit analysis precede the listing of a substance for regulation or only be applied to the remedies that are subsequently applied to remedy whatever is perceived to be the harm? And the majority of the court, 5-4, with Roberts agreeing, took, I won't say a radically unprecedented, but a post-Chevron quite unusual approach of very, very broadly reading the cost-benefit mandate into language where it does not clearly appear. So one way to read Roberts' actions and a majority of the court's actions is that this was kind of a shot across the bow, the executive agent saying, watch out, we're rethinking Chevron. The other case, of course, with which you can combine ACA is Obergefell. And in Obergefell, the same-sex marriage case, Roberts made no few, I don't recall the exact number, I think it's 16 references to Lochner, which raises a fascinating question. Why Lochner? And of course, we all know a version of the answer, but it's still a question worth asking. What exactly is going on in this particular case? And one answer is, of course, that Roberts was castigating the majority for engaging in what he viewed as old-school substantive due process invention of fundamental rights out of the air, just as had been decredited in the Lochner court so many years ago in 1905. This was the argument that Justice Rehnquist, as a clerk, presented against Brown versus Board of Education. This has been a long-standing conservative judicial argument against courts finding novel theories of equal protection and rights. But in the current era, that's actually not the environment. As many of you probably know, in the current era, we're in an environment which a lot of conservative judicial writers and judges are calling for a revival of Lochner-era substantive due process. Janice Rogers Brown, for example, with her ode to the death of cowboy capitalism. There are a lot of conservative writers who are pushing Roberts and the other conservatives on the courts to gleefully wade into the substantive due process arena and find, or rediscover, if you like, property rights, contract rights, and other contractual guarantees of precisely the sort that were discredited after the 1930s. And Roberts' opinion can equally be read as a warning to those people that he does not want to play that game, that he is not interested in seeing the court turned into a direct instrument of partisan policy, which you can read as a critique of his colleagues to whatever degree you like, but he does not want to be in that position. And he's going to use the age-old warnings of Lochner, which we remember from Griswold, for example, and the abortion cases, right? It was always, in those days, conservatives who were saying, don't revive this substantive due process. It leads us into morass. Here is Roberts arguably making exactly the same warning against his conservative colleagues as well as his liberal colleagues. Don't forget, he did dissent from this case. Let me not misstate that outcome. So when you go back to the AEC case and read it in partnership with one or the other or both of these other two, you get a slightly more nuanced view, I think, and a somewhat different one. On the one hand, it seems to me that Roberts has made a pretty strong statement that he's willing to reconsider Chevron deference, particularly in a certain class of cases, but we don't have any criteria at all for what those cases are, ones that are particularly important. Well, then you say, wait, surely Obamacare is the quintessential exemplar case of a particularly important law, right? Surely this should have been the non-deferential case, and we should have second-guessed the IRS. But that gets us to our counter-principle, which we saw in Roberts' opinion in Obergefell, which is, I think, that institutionally he's not willing to see or how should I phrase this? He is reluctant to see the court drawn further as an institution into being viewed as an instrument of politics. We just heard a long discussion about the political struggle to change or amend or get rid of or replace the Affordable Care Act with a number of very smart political comments, including the need to have a viable, serious replacement, the fact that different pieces connect, the fact that you might go after one piece, go after another piece. Those are all political stratagems. There have been 50 votes in Congress attempting to do this. There have been elections. There will be more elections. The political process is not over. But Roberts, I think, is unwilling to let the court put its stamp on this outcome, and if I can draw a direct analogy, in the way that in the eyes of critics of the court, rightly or wrongly, occurred in Bush versus Gore. And let me leave you with one final thought before I pass the microphone on, which is one of the most important polls that I know, recurrent polls, longitudinal studies. It's done by the Pew Foundation. It's confidence in institutions. And for many, many years, no matter what happened, confidence in the Supreme Court remained very high. In the last 20 years, it has dropped to all-time lows. Confidence in the Supreme Court as an institution of the law and not politics is down in the low 30s. That's the lowest it has been since measurement was first taken in the early 1970s. Lower than during Watergate, lower than the day of Bush versus Gore, lower than, think of all the things that have happened, lower than after Roe versus Wade, lower than any of those points. Something has happened in the last 5, 6, 7 years. You can look at the data. It's, finding the precise inflection point is always an interesting question. But there's been a very steady, unbroken downward slide in the last decade or so in confidence in the Supreme Court. I think Roberts is cognizant of that fact and deeply concerned about it. And I think that as judicial conservatives, as well as political and policy conservatives, perhaps you all and I ought to be concerned about that too.
Thank you. Mr. Miller, a response?
Sure. Let's talk for just a moment about the canons of statutory construction. Sometimes they fire in different directions, sometimes they don't fire at all. You fire them up when you use them for a particular purpose. I'm sorry to say blunt about this, but it's been all over the lot on this, and in this case, some were left unfired and others were fired. It's not a mechanistic process. There was no legislative intent here, after all is said and done. There were a lot of legislative intents, but no single one. There were multiple intents at work here. There were policy mistakes, and policy mistakes need to be corrected by a Congress rather than a court that rewrites it. Justice Roberts has a pretty strong track record at this point of not just being a neutral arbiter. He rewrote the law 2 times before in terms of finding that the individual mandate was a tax rather than a penalty, despite what everybody else thought they were doing and what this Congress professed quite aggressively in all the legislative text itself as to what they were going about, for political purposes disguised perhaps. Then he rewrote the Medicaid statute to find a different type of Medicaid statute rather than a full unconstitutional provision, which would have pulled the entire thing down. So here we've got the third example of just coincidentally rewriting a statute which happens to only point in one direction after the rewrite as opposed to what it said before. You can pull up all kinds of Supreme Court cases in recent years which can go in all directions over the lot. Take a look at Bay Mills. which basically said we're not going to fix mistakes that a legislature does. And there's some other language in some cases earlier this year which could hint at that in different provisions. So I don't mean to be some type of critical studies legal pragmatist that says this happens, but that's what our courts are doing. They shouldn't be doing this. We should argue for more principled guidelines and rules and standards, but you have to look at that. I mean, I went through the torture of reading a Cass Sunstein Law Review article last night, which I don't recommend to anyone, about this whole evolution of Chevron all over the lot. If you look at the result they want, maybe you can figure out what the reasoning is, but if you start with a standard set of reasoning, you're not going to get a consistent set of results in this type of administrative law review. Many people did this after the NFIB Sibelius case to find some saving graces in the tea leaves. The chief was looking to something else further on down the road. He was much more clever than you realized by calling it a tax, etc. That's just wishful thinking. You have the decision that you have when it's in front of you as to whether or not the law is what it says or it's something else. This was not a Chevron analysis case. It was rather aggressively pulled out of the arms of Chevron by the chief saying, we're the courts, we're in charge, at least when it's a case we care about and we want to support a statutory scheme. That's the subtext in this. And trying to dress it up as some type of consistent, sophisticated, principled analysis defies the actual language of the opinion, the arguments behind it. Now, you can make other arguments. What did it take to get Roberts and Kennedy on board, as opposed to what the other 4 justices would do? And that was their little sop in return to dent Chevron to some extent. And I've had administrative lawyers say, oh, we're going to really do well on these environmental cases. I know it was in front of the court right now what mattered, what the law was, and that's a decision that needed to be made, as opposed to thinking there's some saving grace in a lesser extent of partially trimming a very troubled area of administrative law.
Mr. Miller, you and Professor Schwaber seem to agree almost on the subtext. My question back to you is, what do you think is motivating the Chief Justice? Is it, as Professor Schwaber indicates, trying to restore the court's credibility, so to speak? Or what is motivating him?
I don't like to psychoanalyze justices. I think that's a fruitless enterprise. I think you have the language that he wrote, and you need to take it in its own terms. You can go through all kinds of, and that's what 1,000 law review articles and softer blog posts are written about. And we have no shortage of those. And you can go all over the lot of that. I say let's take it in its own language. Let's examine whether it holds up or not. How many acrobatic contortions you have to go through, and there are weaknesses on the other side of the case as well. I just don't think it's a convincing opinion if you're trying to get to the law and a decision, as opposed to starting with the result and working backwards from it.
Professor Schwaber, reaction?
It's interesting that ultimately we do agree on one very, very central point, which is that this case, as well as the other cases that I mentioned, were pulled out of the Chevron framework. We differ on what we conclude from that fact, but there's no question that it's very notable that repeatedly this term, not only in this case, the Chevron framework was set aside. Now, I read that as setting aside what in administrative law is usually regarded as the most deferential framework ever articulated by the Supreme Court. So moving outside the Chevron framework is, as you say, the court saying we're the courts, we'll decide what this means. That's a reduction in deference, not an increase in deference by any measurement that I can think of. To me, that's what jumps out about these opinions. But we do agree on that substantive point, and I think it is a crucial one if you have any interest in separation of powers, administrative law, and political accountability, as I think you'll be going to. Second comment, and this might be much a matter of tone and focus as substantive agreement or disagreement. I was a litigator for 5 years. I fully understand what it means to be a litigator and practice that kind of law. Now I try to engage in some of more abstract scholarly analysis. It's 2 different ways of thinking. I'm not as interested in this case in terms of what avenue does it lead for the next case or who will win the next argument, as I'm interested in what does it show about the evolution of constitutional doctrine with respect to separation of powers, the role of courts, and the treatment of special cases in general. So, for example, I am interested in the way we the ACA and EPA cases together and look ahead to carbon emissions. And you find the court has established a very strong basis for striking down any attempt to regulate carbon emissions, which didn't exist before this year. They created this by this excision of set of cases from the Chevron standard under the important cases doctrine, which is reliable as an old and previously, an old doctrine that I won't say had been discredited, but certainly had fallen into desuetude over an extended period of time. So it's a little bit surprising to hear this old standard brought up back into the hit list. So I think this is, to a certain extent, less a matter of outright disagreement about the the events as to how to read them and how to look at them. I think if you look at this along with other cases this term and the last term and the patterns of treatment of statutory interpretation, it's quite true the canons point in all different directions, but it's also true that what is exceptional is in holding a statute to its specific terms. That's not what traditionally happens. And what's exceptional in this term is the number of times that did occur. It's not what occurred in Bond. It's not what occurred in Yates. It's not what occurred in EPA. So it's exceptional when it does occur. One more case you might want to look at, just as an interesting comparison, and this is the last thought I'll try and leave you with, if I may. When I teach constitutional law, I mentioned this to someone earlier, I try very, very hard to tell students, I almost beg them, please don't use the words conservative and liberal. Not that these words are meaningless, of course that they're not. They're deeply important politically, they're deeply important in policy, and there's a meaningful sense of judicial conservatism and judicial liberalism. These are all meaningful terms. They just don't map perfectly onto each other. If you attempt to define someone solely as a conservative in a policy and political sense, then you'll be troubled by the fact that Justice Scalia is one of the strongest supporters of procedural rights for criminal defendants. That's not the typical, standard, political conservative line as we're taught it. If you try to argue that a political liberal is the same thing as a judicial liberal, just sort of as a general proposition, then you may be puzzled to look at Zivotofsky, the case about the birth certificate in the city of Jerusalem, and look at the line about who was supporting power for Congress and who was supporting power for the executives. All of these things don't cleanly and neatly follow a pre-ordered, perfect order. That's true. No one is perfectly consistent. Most justices, most of the time, do follow a fairly consistent judicial philosophy, and this has been tested empirically as well as philosophically. You can do much better predicting what's going to happen if you think about their constitutional and legal interpretive philosophies than by simply saying what does one party or the other favor.
Thank you. Senator Johnson, the court seems to be in a form of disarray. What is Congress's reaction?
Well, that's an easy question. Now for something completely different. I am the non-attorney here. I always enjoy going last because it's interesting to follow up with what's been said. You also never know exactly what you're going to say, so this will be a little more disjointed than what a normal one of my discussions might be. But let me first make a couple comments. It's been stated here on the panel that the court is not in real good repute with the American public. Very low opinion polls from the standpoint of politicization. I think there's some other comments that point to why that is. I think Tom said some of these votes were in the bank. And as a non-attorney, I listen to the back and forth here. I read the opinions. I read all the things that have been written about the opinions. And as a non-attorney, it really is. It looks to me like people arguing how many angels dance on the head of the pin. I come from the business world, a problem solver, where in the business world, the KISS principle is probably the more important jurisprudence bedrock is, keep it simple, and I won't say the last word. How do we simplify these things? And as a non-attorney watching this process, it's really jaw-dropping. How can you take a law that's been written where you've got people that were very involved in writing the law, a guy like Jonathan Gruber said, no, this is exactly the way we designed the law. This is exactly the way. We wanted to coerce the states into establishing their exchanges so the federal government didn't have to. So the way we incentivized them to set up their exchanges is we said the subsidies will only flow through exchanges established by the state. And yet the court, these judges, John Roberts, who said he was going to just be the umpire. He was going to call balls and strikes. He is changing the strike zone. I think he's refereeing an entirely different game. So again, as a non-attorney who's not fully steeped in the whole Chevron process, again, this is a lot simpler than what it's being made out to be, from my standpoint. And I think from most Americans, you take a look at this. How can this be? Now, and so I think what you're really dealing with here is the issue of basically separation of powers. And certainly over my lifetime, I've seen an explosion in the increase in the power of the executive, and I would say the judiciary at the expense of Congress. Now, a lot of it's Congress's fault. The fact, if you take a look at the federal budget, for example, and you've got about 1/3 that's appropriated and 2/3 that's on automatic pilot. They pass these laws, and they're automatic. They don't have to be renewed. It's just, you qualify for benefit, you get it, no matter what it costs. And so 2/3 of our budget is completely on automatic pilot, out of control. That's one problem. The other problem is the way we write the laws. We don't write laws anymore. We write frameworks for the fourth branch of government to create the law. Obamacare is a classic example. I believe the word count, and I use word count because you get different pages based on how many words you print on the page. The word count for Obamacare, I believe, was 380,000 words. Last time I looked at this about a year ago, it was up to 12 million words. Dodd-Frank was 350,000 words. It's up over 15 million words. And so as Jonathan Turley, and he described himself as a liberal law professor. I know people question that based on his testimony before Congress. He says we have developed this fourth branch of government, and we are at a constitutional tipping point. And I think that's what we're witnessing here. Now, you combine the fact that people no longer, or certainly losing their respect for the Supreme Court as being just a nonpartisan judicial panel. A group of 9 individuals, patriots, that are going to look at the law and apply the law and render a decision. But when you've already got 4 and 4 in the bank, and you got 1 swing vote, what's being decided here? It's all about one person. And I think that's a real problem for our constitutional form of government, and certainly separation of powers. And so I think Congress has got to reclaim its proper role, and let's have a balanced, equal, separation of powers in this constitutional frame of government, which, again, I think we've by and well lost. One of the things I tried to do in reaction to King versus Burwell, and this really, we were originally going to have this panel discussion before the decision, but things didn't work out. I was anticipating. I was trying to problem solve. I wanted to make sure that if the court ruled the way I thought they should have, actually followed the law, the very clear wording, the very clear intent based on people that crafted it, there was going to be turmoil. There was going to be chaos. Now, we certainly had a number of working groups in the Republican conference, both the House and Senate, trying to work on what our response would be. Part of the problem in Congress is a bunch of cats, okay? And it's hard to herd cats. I always say you really can herd a group of cats with a bright red piece of tuna. That'd be a strategy or a goal, but you got to keep the tuna bright and fresh. That's a strategic planning process. So we are actually going through a process of developing a response for the opposite decision, King versus Burwell. We weren't coming to consensus. So a couple months ago, frustrated that we hadn't developed a consensus, nobody wanted to stick their neck out, okay? I stuck my neck out. And so I not only wrote an op-ed that ran the Wall Street Journal to lay out my rationale, what my goals were, but actually introduced a pretty simple piece of legislation that I thought was pretty fair. I think proof in the pudding that was pretty fair is I've been attacked by both sides. The name of the bill, by the way, is exactly what I thought it would have achieved, unlike the Orwellian-named Patient Protection Affordable Care Act, which has done neither. The name of my bill is Preserving Freedom of Choice in Health Care, and it's pretty simple. And by the way, even though the decision went against us, I don't believe it's moot. I think it's still applicable in terms of what we need to start doing. But what my bill would have done is, first of all, if you like your health care plan, you could keep it, even Obamacare, even your subsidy, till the end of August 2017. And the reason I set it up that way is I actually wanted the American people involved in deciding what direction our healthcare system would take in an election. We weren't able to do it in 2012, by the way, because at that point, what Obamacare was going to result in was just theory and conjecture. It still is. And as Andrew was talking about, is you just don't have consistent information. It's not coming from the government. We're having to rely on studies and different think tanks. And everybody's got their own set of facts. What we have is we have anecdotal evidence. Again, so we just don't have the information we need to really convey certainly my concerns about what Obamacare is. And we had even less in 2012. Well, fast forward, in 2013, as they started implementing this law, we found out that President Obama's PolitiFact lie of the year for 2013, that if you like your health care plan, you can keep it, period. If you like your doctor, you can keep it, period. Well, that was a massive consumer fraud. People know that now. So we can run an election in 2016 to have the American people render judgment with all the good and the bad. Let's face it, there's plenty of people being advantaged from Obamacare. I can't tell you exactly how many because I don't have real good information. But we know it's millions of people that are participating in the subsidized care. But here's some information from the Manhattan Institute. If you don't get the subsidy and you're forced to buy an individual policy on the exchange, in Wisconsin, again, this is according to Manhattan Institute from the first year of the implementation of Obamacare, if you're a 27-year-old male, your premium increased on average 138%. If you're a 27-year-old female, it went up 89%. Now that's doing real harm to real people. It just doesn't get reported a whole lot. But anyway, back to my bill. If you like your health care plan, you can keep it, and we set up an election. Beyond that, all I was asking in exchange for kind of cleaning up that mess was, you know, let's preserve some freedom of choice in health care. Let's get the IRS out of the business of, I guess it's taxing people. We all know that was a penalty. Okay? So we would eliminate the individual mandate. A very unpopular part of the bill, I think a very coercive part, I think a very unconstitutional part, but that's just my opinion. Let's stop forcing Americans into part-time work. We'd eliminate the employer mandate. And again, there's more and more anecdotal evidence of people taking a look, you know, even with, just saw an article, a really good op-ed written by the CEO of Carl's Jr., talking about the increase in minimum wage laws. People in his restaurants are coming to their managers and saying, I can't work as many hours because I don't make as much money, I don't get as many benefits. So there's some real world, unintended, but very negative consequences to all these welfare programs, you know. So let's stop forcing Americans into part-time work. We eliminate the employer mandate. And then the final element was let's stop artificially driving up the cost of health care with all these expensive mandated coverages. I mean, I really don't need maternity coverage. I really don't. I shouldn't have to pay for it. So I would have turned those choices, I would have returned that freedom to individuals and regulators in the state to determine what type of coverage ought to be provided for their citizens in their state. I mean, that's really our Federalist form of constitutional government. So I would have been looking to preserve freedom of choice in health care, and then my final comment will be that's, I think, what our reaction needs to be now over the ensuing months before the election and afterwards. You know, for my part, I'm obviously going to turn away from what my response would have been to the King versus Burwell if King would have won, to providing the information, trying to gather it, trying to sift through it, trying to give certainly the citizens of Wisconsin, hopefully the American people, the truth. You know, let's try and agree on some numbers here. Let's try and agree on some facts, because you'll never solve a problem if you don't have information. So again, coming from a problem-solving process, I mean, you first go to a root cause analysis. What has been driving up the cost of health care and limiting improving quality and levels of customer service? I mean, I would argue it dates back to the 40s. I won't give the full history, but back then, little fact, 68 cents of every health care dollar was paid for by the patient. So you had some free market disciplines in the health care market. Now, I don't, you know, whether you participate in the free market or not, let me tell you what the free market by and large guarantees. 3 things. By the way, when I was participating in it, I would have loved to have been a monopoly. Now, I didn't really like competition, but I knew because of competition, my prices were a lot lower than they would have been otherwise. My quality was a lot better, as was my level of customer service. That's what the free market guarantees. So the solution should be, how do you get the benefits of the free market discipline involved in healthcare? Because today, only 12 cents of every healthcare dollar is paid for by the patient. Because you've got government paying at whatever level, somewhere between 40 and 50% of all healthcare expenditures. The rest of that 88 cents per dollar is paid for by a third-party administrator, an insurance company. Now, we can, you know, complain about how much we're paying in premiums, and there's competition to a certain extent with premiums. By the way, less and less. As you see, Aetna now taking over Humana. You know, just like Dodd-Frank, you know, we're supposed to fix too big to fail. We didn't. We exacerbated the problem, right? We've consolidated the financial industry. The same thing's happening now with healthcare. We're consolidating it. We're going to take even more of the free market discipline out of healthcare market, and we are on the path toward turning America's healthcare system into something else that's a government-run healthcare system. And now we've seen in the state of Wisconsin what that's going to look like. It's called the VA healthcare system. I don't think Americans are going to like that. So again, root cause analysis, what we need to do is we need to interject free market disciplines into our healthcare system. And by the way, we are on the path to do that with things like HSAs. Certainly what I did in my business, we saw our healthcare premiums increasing, went to my employees and said, listen, we've got to do something about this. Here's what I'm going to do. We're going to go to the higher deductible plans required by HSAs, but I'm not going to pocket the premium savings. What we did instead is we took the premium savings, divvied out by the number of employees, and we invested in HSA accounts. Within 3 years, we had $5,000 per employee in their HSA account. Now that's their money that they're going to spend on those first dollars of health care, and is going to interject free market discipline. In other words, you're going to reconnect the consumer of the product with the payment of the product. You're going to address the root cause of the problem, and that's what we should be doing. So I'm hoping that what Congress's response is going to be is take a look at the law, take a look at what we can utilize in the law. There's nothing wrong with state exchanges. That was actually a Heritage Foundation idea. No, there's nothing wrong with that, as long as the healthcare plans being offered on these exchanges are done in freedom, designed in freedom, from the free market system. Give people the respect that they actually know they have the intelligence to choose what kind of health care they want, what kind of plan, what kind of deductibles, what kind of coverage. Let's throw that respect back to the American people, the citizens of Wisconsin. You know, believe that they're actually smart enough. One final point before I open up to questions. I wish, if there's one law I'd like to pass, and by the way, that's part of the problem in Washington, is everything's additive. After all, it's a legislature. You know, it's populated by legislators, so they pass bills. We need a process of subtraction. But here's one bill I'd like to add. Let's ban the word comprehensive in our bills. We don't do comprehensive very well. You know, so let's start doing a rifle shot approach. Let's take a look at, you know, we've got Obamacare now. I mean, I was pretty depressed by the King versus Burwell. It pretty well cements that in place. We're not going to repeal it anytime with President Obama in office. Let's start going to the American public with facts, with figures, with information. Let's start taking a look at the more harmful parts of the law. You know, either through reconciliation, which is a difficult process, by the way. I mean, nobody really knows exactly what you can run through reconciliation. The parliamentarian will rule on that. They call it a bird wash, okay, because of the bird rule. But let's take a look at the more harmful aspects of things that are doing real damage to real people. Let's try and put those repeals on the president's desk. But by and large, let's lay out the information for the American people in the 2016 election. It will be very incumbent on Republicans' nominee for president to lay out his or her vision of what health care is going to look like in 2017 and beyond. That's the proper place to have this debate, because one of the reasons that Obamacare has been so divisive is it was passed on a purely partisan basis. Something so important, you know, such a monumental rewrite of a sixth of our economy, and it was passed on a partisan basis. Well, it's not really surprising that we've had a real division in terms of our politics, which, kind of getting back to where I started, the Supreme Court. It's not good when these societal changing types of decisions come down, and instead of like Brown versus Education 9-0, they're 5-4. That's not good. And again, that's, I think, part of the reason that the Supreme Court has lost, certainly respect the fact that it's an impartial panel of judges that are just going to call the balls and strikes. You know, it's probably Pollyannish on my part. I sure would like to get back to the point where the Supreme Court is made up of those jurists, those judges, that will just rule on the law, and we'll have surprises all over the place from different judges. Boy, that's interesting that that individual would vote that way. That's just rare nowadays, just from my layman's perspective. We need to get back to that point. Congress has got to reassert itself. It's got to control the budget. It's got to start addressing Obamacare on a bit-by-bit basis. And like I say, transition from where we are today to a more patient-centered type of system that actually utilizes the benefits of a free market system to actually control costs and improve quality and levels of customer service. With that, I'll open up to questions.
Thank you, Senator Johnson. Audience members, question and answer. We have time for a few. Okay, I will throw one out then. Senator Johnson, being somebody on the front lines of developing legislation, what do you think when you hear the following numbers? So the Gallup poll in April found 50% disapprove of Obamacare, yet 46% said expand it or implement it. Another poll found only 29% said repeal it, and in light of the King versus Burwell decision, a poll found 62% of Americans approve of the decision. How do you make sense of those numbers when you're crafting policy?
Well, first of all, we're a very divided nation. And that's really kind of explains where we're at right there. But we are divided from a standpoint of the fact that we don't really go to the American public with real information. We go to them with political demagoguery. We push the buttons. And that has resulted in a financial situation right now that's completely unsustainable. Have you ever heard anybody say, any elected official go, oh no, we're in a completely sustainable spot right now? But they don't define unsustainable. Because if they define it, if they acknowledge the reality, we're going to have to do something about it. A little off subject, but let me talk about the reality denying that's going on inside of Washington, D.C., but right in the White House. I was one of those 8 senators who was trying to work with President Obama, trying to find common ground, at least on making progress on our debt and deficit. So I was in the White House for about a 2-hour meeting. President Obama joined us for the last half of that meeting. And of course, what I had done is I'd kind of brought in my problem-solving skills, defining out the problem. By the way, it's not a 10-year budget window problem. And if you just talk about unfunded liability, that's over everybody's head. Well, I'm dead back then, or at that point in time. So I said, really what we have is a 30-year demographic problem. All the baby boom generation, we're retiring at the rate of 10,000 people per day, made all these promises, can't pay for them. So what is the 30-year deficit? Well, CBO actually does some work on this. Their latest projection, by the way, is for $103 trillion over the next 30 years. We're going to hold a hearing on that on Thursday. $130 trillion. Now, the entire net private asset base of America is a little under $110 trillion. So I'm in the White House, and President Obama, of course, out of that negotiation, he wanted a tax increase. So, well, Mr. President, fair enough, put everything on the table. Here's how you get everything on the table. Use your bully pulpit. I've gone around the state of Wisconsin. I've given my PowerPoint presentation. I've taken rooms like this full of smiling faces, turn those things into frowns. And then I get accused of lecturing, sorry. But I think people need some information. I said, use your bully pulpit. I'm a pretty small voice. I've done that to about 17,000 people. This would be a big audience. But use your bully pulpit. Take the truth to the American public. Show them the depth of the problem so that collectively we can take the first step in solving any problem, which is admitting we have one. You know what he said to me? He said, Ron, we can't show the American public numbers this big. If we do, they'll get scared. They give up hope. And he said, besides, Ron, we can't do all the work. We have to leave some work for future presidents, future Congresses. Now, I've told that story at least 100 times with press in the room. You know how many times it's been covered, reported? Twice. So we're not going to solve these problems unless, first of all, we have elected officials that have the courage to tell the citizens the truth. But it has to be the truth. We've got to have information. You can't deal with numbers all over the board. Because, trust me, I talk to a lot of people and go, those are your numbers. Everybody's got their own numbers, and to a certain extent, they're right. So we've got to come together. Again, here's my business background. Let's say you're going to start a negotiation for a business. If you've got the seller with one set of books and the buyer with another, totally different, trust me, you will never come to successful negotiation for the sale of that business. Well, that's where we're at really politically. One side's got their group, their set of numbers, the other side's got their set, and we're not meeting in the middle. So that's the first step in solving any problem. Lay out the reality situation, agree on the numbers, agree on the extent of the problem, then you start developing strategies, and once you've developed different strategies, now is when you start compromising. Okay? Compromise isn't the first step, it's the last step in the process, and I would just argue that today, collectively, we have not come to terms, we have not as a society admitted we have these problems, and that's true with Obamacare. It's very difficult to, theorize in any convincing way, really, from my standpoint, how damaging Obamacare is going to be to our healthcare system. Right now, my ace in the hole is really lay out, because we are on the path toward a single-payer system. And that was, you've heard that as a repeatedly stated goal. This is the first step to a single-payer system. Well, now America, because of revelations in Arizona and in Toma, Wisconsin, people have a pretty good sense of what a government-run healthcare system is like, and it's not very pretty. They're not going to like it. We need to get off that path.
Thank you. Well, I think we'll wrap it up. One question. Okay.
Just a quick question for the panel. First of all, I just wanted to say thank you so much for coming today. It was really, as a non-attorney myself, it was a really fascinating discussion. But just quickly, so Senator Johnson, one of the things that I've been following recently is your suit against the Affordable Care Act. So I'm just wondering, in light of King v. Burwell, are you intending on continuing that suit, or will you drop it and just acknowledge it as law right now?
So just a quick repeat.
Sure.
The question is, given Senator Johnson's suit, what will he, lawsuit that he's been pursuing, what will he do now with King versus Burwell?
Let me first say that was not a real popular lawsuit on the part of my colleagues or within Congress. Okay, they like their special treatment. No offense to lawyers, but I avoided attorneys and the legal process like a plague for 31 years. Okay, but I have been involved in a couple different issues on the law, and I always find them fascinating. I really do understand why people are drawn to the law, because it is fascinating. It's fun arguing how many angels can dance on the pin. It's a competition. I really get that. So, from my standpoint, I thought this was pretty basic. I had to first establish standing. Certainly from our briefs, I was thoroughly convinced that I could obtain standing from about 3 different angles. Administrative burden, I won't get into the whole lawsuit. If I could have obtained standing, I think it would have been a slam dunk against the administration, and members of Congress would have lost that special treatment, okay? But I thought King versus Burwell was a slam dunk as well. So I've got a couple more weeks to decide whether I want to try and obtain cert in front of the Supreme Court. Obviously, I was trying to highlight the abuse of the process, and again, here's another part of the law. And again, it was actually written so that members of Congress were subjected to the law, but as the administration, in response to members, saying, "Whoa, look at what we did. We can't put up with that," actually did this, I think, an unlawful ruling under the law. My problem is I've got no faith in the Supreme Court, even if they were to grant cert on it. I'm not real confident that they would take this, because it might start. Trust me, if members of Congress were fully subjected to Obamacare, that was always my thought process. That would probably be the best thing we could do to unravel the law. Okay, so I'm still going through the process. I kind of have my doubts because partly because of the decision in King versus Burwell. It's like, even if we got cert, I know there are going to be some votes in the bag. So what are really the chances? From my standpoint, there are bigger issues to deal with right now. I think it's more important to really start laying out the case against Obamacare and really run, is certainly part of the issues in this election, on those facts, and that's going to take a lot of my time as well. So I'm not sure I want to be distracted by taking this one more. By the way, it also costs a fair amount of money, okay? And I'm not sure I want to spend $100,000 just trying to get cert before the Supreme Court, okay?
Thank you, and thank you everybody for attending. Thank you, panelists. You did a wonderful job.